Hi again. This is Lydia Lockett. I practice in Holland and Knight's Trust and Estates Fiduciary Dispute Resolution practice down in Los Angeles.
My name is Andy Verriere. I'm an attorney at Hartog, Baer in Orinda. I also do trust and estates litigation for 10 years now.
And we're going to be talking to you about some top 10 myths about privilege in the trust and estates context. So with that, we're just going to jump right in. So myth number one, that attorney work product privilege is always waived when you turn a memo, for instance, over to a client. So that's the myth. In reality, it's a little bit more nuanced than that. It's not waived once you turn it over to a client, as long as it is transmitted to the client in confidence. And that can be determined with an in-camera review with the court, or if you're able to show that it was at some point. And an important note is that the attorney work product privilege survives the termination of litigation, and a client can assert it on behalf of their attorney once the representation is over, because the interests between the attorney and the client's interest in preserving that from disclosure are essentially aligned in a case like that. The second myth, that an attorney can't assert attorney work product privilege against his or her own client. This is going to depend. There's a specific statutory carve-out for actions where you're bringing a malpractice claim, for instance, against an attorney for a breach of their professional or fiduciary duties to the client. In that instance, they cannot assert the attorney work product privilege against the client. In all other instances, though, there are a string of cases that clearly hold that the person who holds the privilege is the attorney, not the client. So they can assert the attorney work product privilege against their client. But one rule to be wary of is the ethical obligations of an attorney to turn over any information or files that is reasonably necessary to further the interest of their client or former client. And they have a duty not to prejudice their current or former client's interests. So there's this strange tension between what they're statutorily allowed to do and what they're ethically obligated to do in an instance such as that.
So the next one is that all attorneys' notes are entitled to attorney work product protection. And here we get into the distinction between absolute work product and qualified work product. And in order to determine if an attorney's notes are potentially discoverable, the real question is what the content of those notes are. So if it contains the attorney's impressions, conclusions, or analysis of a case, that's going to fall under the absolute work product and won't be able to be turned over. But if it is an attorney simply taking down a transcription of statements made, that would likely fall under qualified work product, and under a certain showing of necessity could be ordered to be disclosed. And there's some interesting cases that parse this. In particular, there's a case called Rodriguez versus McDonnell Douglas, where the court looked at notes that contained both an attorney's transcription of a witness statement as well as contemporaneous analysis and commentary by the attorney on it. And the court observed that while the witness statement in and of itself was not absolute work product, because they were so intertwined, it couldn't differentiate between the absolute and the qualified work product, and everything was considered to be work product. I'm sorry, everything was considered to be absolute work product. The next myth is that the attorney-client privilege survives death indefinitely. And this is an issue that came up in a case regarding Bing Crosby's estate called HLC Properties, where the estate had actually been fully distributed to a subsequent partnership. That partnership attempted to assert the attorney-client privilege, and the court observed that because there was no personal representative at the time, there was no one that could actually assert the attorney-client privilege, and without someone that can assert it, there's no privilege. Subsequently, the legislature amended this, and now there's a provision in Probate Code 12252 that allows the appointment of a special administrator or some sort of personal representative specifically to assert the attorney-client privilege. So if you're ever in a situation where the administration has been completed, Unless and until a subsequent special administrator is appointed, there is no holder of the privilege, and it's quite possible that the privilege no longer exists. And so on that point, to sort of unpack the question of whether there's attorney-client privilege post-death, you really need to look at what the privilege applies to. So if it relates to the estate planning, that's covered by its own section of the Evidence Code under 957. If it relates to trust administration during the person's lifetime, that privilege likely passes to the successor trustee. But if it relates to something else that would otherwise be held by the special administrator, unless and until a special administrator or personal representative is appointed, there's no one to assert the privilege and it's not there.
So I'm going to go through myths 6 and 7 pretty quickly. They're pretty related. So if for all those people who practice federally, you should be familiar with the Garner Doctrine. The Garner Doctrine essentially provides that there is a fiduciary exception to attorney-client privilege. And that case essentially dealt with a shareholder derivative action where shareholders of a corporation were trying to access attorney-client communications with corporate counsel. And the court there held essentially that because the board of directors were acting in a sort of fiduciary capacity for the benefit of the shareholders were entitled to get that information. So myth number 6 is that this Garner Doctrine applies as a fiduciary exception to the attorney-client privilege. No, it doesn't. Not in California. California, all the exceptions are statutory only. The Garner exception is a doctrine, federal case law, and there are some cases in California that have basically explicitly disapproved of using the Garner Doctrine in the trust and estates context, trying to put the beneficiaries in the same shoes as the trustee or as joint clients or color them in any way of that sort. So it's not going to apply in your trust and estates cases in California, so don't try to use it. On a similar note, does the Garner rule or the Garner Doctrine apply in the case of closely held corporations, which we often deal with in trust and estates? Again, statutory exception. This is not one of those statutory exceptions that applies here. So you're not going to be able to use the Garner Doctrine in any of your trust and estates cases unless you're practicing in federal court.
Myth number 8 is that the presence of third parties always destroys the attorney-client privilege. So, when we think about the privilege, we think about this sacrosanct communication between the attorney and client, and that no third parties can be involved. But what really directs us here is Evidence Code Section 952, which goes into which communications are considered confidential and which are not. And to fall under a confidential communication under 952, it is permissible to have third parties so long as the third person are there to further the interests of the client or reasonably necessary to accomplish the client's goals. So examples we have of that are if a spouse is present. Is it possible that it could waive the privilege? Maybe, but ultimately you have a confidential communication between the spouses. The spouse is likely there to further the goals of the client, or it could be someone there to help provide information to frame the issues for the attorney. So just because there is a third person there, it does raise a red flag as to whether or not it could be no longer confidential communication, but you really need to look at the reason why the third person is there.
Okay, another issue that constantly comes up in trust and estates disputes is the issue of attorney invoices. Often, we would like to subpoena the invoices of a fiduciary's attorney, that is, in order to see exactly what the attorney was spending their time on and what they were billing the trust for. Well, a case came down in, I think, 2016 or 2017, LA County Board of Supervisors v. the Superior Court. The real party in interest there was the ACLU, and the court held that invoices are not per se privileged. You really do need to look at a couple factors, whether or not the invoice or the billing entries were communicating information for the purpose of the legal representation. In the cases of invoices, typically it's just to show, for payment. And the other aspect of it is it going to reveal any aspect of that's going to be relevant to that representation? In the case of litigation, if you see a ramp up in bills and time entries, that could indicate that you're ramping up litigation. So for the cases where you've got long concluded litigation, it's a bit clearer that you can get those types of invoices without triggering the attorney-client privilege, but it still is an issue that potentially could be raised. And the last myth has to do with trustees and whether they're entitled to assert the attorney-client privilege with respect to communications they've had with their counsel, with respect to claims that are brought against them in their individual capacity, such as surcharge or removal. The leading case there is FTIC, which is the Fiduciary Trust International of California case, which essentially holds that the office of the trustee is the holder of the privilege, and that privilege flows with the trustee. Now, to the extent that there is any sort of communications that relate to the trustee's personal liability, you really need to look at the purpose of the communication at the time that the communication was made. Was the dominant purpose related to the trustees, protecting the trustee from further liability, or was it to, with respect to the general trust administration? And also, is the trustee paying for fees out of his own pocket, his or her own pocket, versus using the trust corpus to fund this representation? So you really need to look at sort of the circumstances. It is fact intensive, but the general rule is the attorney-client privilege is going to flow with the office.
Thank you.
Okay, thank you.